Losing a loved one is one of the most difficult experiences any of us will ever face. Amidst the overwhelming grief and the quiet moments of remembering, the last thing you want to think about is a complex legal process. Yet, as the initial shock begins to fade, families are often faced with a confusing and unfamiliar term that demands their attention: probate.
If you are hearing this word for the first time, you are not alone. In this complete guide, we will walk you through what probate actually means, helping you navigate these difficult waters with clarity and peace of mind. At its core, probate is a formal, court-supervised legal process that takes place after someone passes away. Its primary purpose is to ensure that a deceased person's estate is administered correctly according to the law. The process begins with validating the deceased person's last will and testament, confirming it's legally binding. Once validated, the court oversees the identification and inventory of all assets left behind, such as real estate, bank accounts, and personal belongings. Before any assets can be passed on to heirs, the probate court ensures that any outstanding taxes and debts are fully paid. Finally, the remaining assets are officially distributed to the rightful beneficiaries, closing out the estate under the careful watch of the legal system. First, probate is necessary to validate the deceased person's will. The court must verify that the document is legally binding, properly signed, and accurately represents their true final wishes, preventing any fraudulent claims. Second, the process identifies and protects the estate's assets. A court-appointed executor is responsible for locating everything from bank accounts to real estate, securing these assets so they are not lost, stolen, or improperly sold. Third, probate manages outstanding financial obligations. Before any heirs can receive their inheritance, the estate must settle valid debts and pay final taxes. The court provides a strict legal timeframe for creditors to submit their claims. Fourth, it clears the title to assets, allowing for the legal transfer of ownership. Financial institutions and government agencies require official court authorization before they will transfer property deeds, car titles, or account balances. Finally, the probate court serves as a neutral forum for resolving disputes. If family members contest the validity of the will or disagree with the executor's actions, a judge steps in to make a fair and impartial ruling. But what happens if your loved one passed away without leaving a will? In legal terms, this is known as dying intestate. When this occurs, the probate court steps in to determine how the estate will be divided. Without a will to guide them, the court relies strictly on state intestacy laws to dictate who gets what. It's important to note that these laws vary significantly from state to state, so the outcome depends heavily on where your loved one lived. Generally, the law follows a strict hierarchy of next of kin. Assets typically go first to a surviving spouse, followed by children, parents, and then siblings. If no surviving relatives can be found, the state may eventually claim the estate. The probate process might seem overwhelming to grieving families, but it generally follows a predictable set of steps. It all begins by filing a formal petition with the local probate court. This officially opens the estate and allows the court to validate the will, if one exists. Next, all interested parties, including legal heirs and beneficiaries named in the will, must be formally notified. During this time, the court appoints a personal representative, or executor. This individual is legally bound by a fiduciary duty, meaning they must manage the estate with the utmost honesty and put the estate's interests above their own. Once appointed, the representative's first major task is to locate an inventory of all of the deceased's assets, from real estate and vehicles to bank accounts and jewelry. The court will also set a specific timeline for creditors to make claims, allowing the representative to pay off any legitimate outstanding debts. After satisfying creditors and filing all necessary final income and estate tax returns, the remaining assets are officially cleared for transfer. The representative distributes the inheritance to the rightful beneficiaries. Finally, a complete accounting is submitted to the judge, the estate file is closed, and the personal representative's duties are finished. Two of the biggest concerns during probate are time and money. Probate is rarely cheap or fast.
The overall cost typically ranges from 3 to 8% of the total estate value. This money goes toward a variety of expenses, including attorney fees, court filing fees, property appraisal fees, and executor bonding fees. As for the timeline, a standard, uncomplicated probate takes roughly 9 to 18 months. The initial court filing process and appointing an executor takes 1 to 3 months. Gathering and inventorying the assets usually takes another 2 to 6 months. Paying off debts and taxes takes 3 to 9 months, giving creditors a legal window to make claims. Finally, asset distribution and closing the estate takes 6 to 18 months. Keep in mind, if the estate is highly complex or family members contest the will, this process can easily stretch on for several years. While probate can be a lengthy and expensive process, with proper estate planning, your grieving family might be able to skip it altogether. One of the most powerful and popular strategies is creating a living trust. By placing your assets into a living trust, they completely bypass the probate court and transfer seamlessly to your beneficiaries. Another effective method is joint ownership. If you own a house jointly with rights of survivorship, it automatically passes to the surviving owner. For financial accounts, simply add payable on death or transfer on death designations. This allows bank and brokerage accounts to transfer instantly without court intervention. Additionally, most states offer simplified small estate procedures if your total assets fall below a specific monetary threshold, skipping probate entirely. Finally, consider the power of gifting. Giving away portions of your wealth during your lifetime lets you see your loved ones enjoy it, while simultaneously shrinking the size of your estate that is subject to probate. Even with a clear plan, probate isn't always smooth sailing. Families often face unexpected hurdles, like will contests, where the document's validity is challenged, or bitter disputes among heirs. Other common roadblocks include tracking down missing assets, resolving aggressive creditor claims, or navigating complex estate taxes. Fortunately, many of these conflicts don't require a courtroom battle. Professional mediation is a highly effective solution, helping grieving families find common ground and avoid costly delays. Navigating probate while grieving can feel overwhelming, but you do not have to do it alone. Bringing in the right professionals makes all the difference. An experienced probate attorney helps you avoid costly legal mistakes, while a financial advisor and an accountant can ensure estate taxes and debts are handled correctly. Taking care of your emotional well-being is just as important, so do not hesitate to reach out to a grief counselor. Getting the right support team in place will protect your family's future and give you peace of mind. To take the first step, find your local probate court today by visiting probateus.com. We hope this guide on probate has brought you some clarity and peace of mind during a difficult time. If you found this helpful, please like, subscribe, and share. Let us know your thoughts or experiences in the comments below. Thank you for watching, and take care.